Good morning, members of the panel. My name is Zhang, and with me is my co-counsel Mark Maxwell Peter. We appear on behalf of the appellant, Mr. Antonio Fortuna, and I will speak on two issues. First, a procedural issue on my client's statement of appeal, and second, a substantial issue on whether my client's refusal to hand over his mobile phone was lawful and the consequences thereof. I'll speak for 9 minutes and respectfully reserve 1 minute for rebuttal. Then my counsel will speak for 9 minutes on two issues: whether the anonymous email and witness statement is admissible and whether the appellant violated Article 20 of the FDC. Members of the panel, the respondent has imposed a sanction on my client for the alleged involvement in match fixing without regards to the fundamental right of my client, and has not proven that indeed my client was guilty of any of the offenses. As a result, we appear before the panel today to ask that it reverse the FIFA appeal decision. I now turn to the first submission. The question is whether the statement of appeal is admissible, and this arises because the day of the receipt is in dispute, and therefore it is our submission that the statement of appeal is admissible for three reasons. First, the day of the receipt shall be 2nd April 2026. Second, we have submitted evidence that the statement of appeal was in fact submitted prior to the deadline. And third, the cyber attack was an administrative error and should not be held against my client. In defining the concept of decision within the meaning of Article R47, the CAS panel have interpreted the term within the meaning of Article R47 of the Code broadly. In the 2016 CAS decision of Ivan Bellato Palacios versus PFC CSKA Sofia, at paragraph 74 to 75, the panel had found that the Article 15, subsection 2 of the FIFA Procedural Rules 2008 edition explicitly provide that the time limit to lodge an appeal begins upon receipt of the motivated decision, and that it was necessary for the player to get the motivated decision first in order to file an appeal. And in that case, the operative part of the appeal decision was notified on 17 November 2014, and the player requested FIFA for the grounds of appeal on 21st. The grounds of the appeal decision were communicated to the player on 22nd January 2016, and the player lodged his statement of appeal on 12th February 2016, which was the last day within the 21 days set out by Article 67, subsection 1 of the FIFA statute. And at paragraph 75, the panel held that the appeal was admissible as it was filed within 21 days of the FIFA statute. If I may direct the panel to paragraph 26 of the record, I quote, "The decision was fully upheld on 31st March 2026 by the FIFA Appeal Committee, and the challenge decision was sent to the parties with grounds on 2nd April 2016. Under Article 15, subsection 1 of the FIFA Procedural Rules 2025 edition, I quote, "A decision will be notified to a party directly in accordance with these rules." And under Article 15, subsection 4, I quote, "Decisions that immediately impose sporting sanctions against the party shall only be communicated with grounds." If I may direct the panel to paragraph 26 of the record, I quote, "The challenge decision was sent to the parties with grounds on 2nd April 2026. This is Exhibit 7. And at paragraph 27, on 23rd April, the appellant paid a sporting fee of 1,000 Swiss francs and filed the statement of appeal against FIFA before the Court of Arbitration. The statement of appeal was filed by email, addressed to the official CAS email address at 23:34 Eridonian time. Article 32 of the CAS code states, I quote, "The time limits fixed under this code are respected if the communications by the parties are sent before midnight, time of the location of their own domicile." And here the statement of appeal was filed on the last day before the expiry of the 21st day time limit, pursuant to Article 50, subsection 1 of the FIFA statutes and Article R49 of the CAS code. If I may direct the panel's attention to the bottom of page 5 at footnote 3, it states, "Eridonian shares the same time zone as the Court of Arbitration for Sport, and therefore, accordingly, we submit that the statement of appeal is filed within the time frame and is admissible."
Counsel, I have a question. Is Article R49 of the CAS code applicable in our proceedings today, given that the the FDC or the FIFA statute has already given a provision regarding the 21-day time limit?
In this instance, where there is a limit set out by FIFA, the R code is not applicable in this case. However, both of the timelines are the same time. Turning now to the second argument, the respondent has argued that because the statement of appeal had not been received by the CAS court, that would deem the appeal to be late. However, it is our submission that indeed it has been filed within the period of time and that we have submitted evidence to this panel. If I may introduce the panel to the case of the 2013 CAS decision of AC Siena SPA versus Club Desportivo Nacional at paragraph 38. I quote, "The appellant sustains that the statement of appeal was picked up at its offices by an Italian courier company on 19 August 2013, the last day of the time limit, so that the statement of appeal was indeed admissible." And at line 5 and 6, the appellant submits the shipment waybill with the handwritten date of 19 August 2013, stating the company hereby acknowledges that you have withdrawn as of 19 August 2013 at the offices of the Club AC Siena Spa an envelope addressed to the Court of Arbitration for Sport, Lausanne, Switzerland. And the panel in that case held at paragraph 42, I quote, "It has been provided with convincing elements to determine the appeal was timely filed and thus decides that the appeal is admissible."
But counsel, isn't there like a distinction with that case and ours that involves like a career, right? But ours is a cyber attack.
Mr. Arbitrator, respectfully, we disagree. We submit that this case is analogous to our case. In that case, it was the time frame.
Counsel, your time is up. If I can give you about 1 more minute to summarize your submissions.
In that case, the time frame had elapsed. However, the panel, based on the evidence of the shipment bill, had allowed and cured the defect. In the present case, similarly, the defect was a result of the cyber attack, and here we have submitted evidence in Exhibit 8 at paragraph 31 of the record. And therefore, we submit accordingly that the statement of appeal is held within the 21-day time limit. If I may briefly just summarize these, go on to the second submission. The respondent imposed a 5-year sanction when my client refused to provide his mobile phone. It is our submission that the refusal was lawful for 2 reasons. First, the privilege of self-incrimination applies, and second, the evidence has not sufficiently established my client was involved in match fixing.
Your time is up.
Thank you.
I realize Mark doesn't follow IRAC.
Yep.
You also know,
Huh?
Mark doesn't follow IRAC.
Still recording.
That's huh?
Still recording.
But just
We can cut that out.
can you guys just both shift to the right side here? Yeah, that's good.
You want to look formative?
Yeah, of course. It's because of
Good morning, members of the panel. My name is Seah, and together with my co-counsel, Mr. Ramesh Kanna, we appear on behalf of the respondent, the Federation International de Football Association, FIFA. I'll be addressing the first 2 issues on appeal for 10 minutes, namely whether Mr. Fortuna's statement of appeal is admissible, and thereafter whether his refusal to surrender his mobile phone was lawful, together with the potential legal consequences that may ensue. My co-counsel, Mr. Ramesh Kanna, will address the remaining 2 issues, and we will each take 10 minutes. And we respectfully reserve 1 minute for our rebuttal. Members of the panel, the present dispute concerns the protection of the integrity of football as a regulated sporting activity. The imposition of disciplinary sanctions, together with the obligation to cooperate, constitutes key fundamental mechanisms by which sporting bodies ensure transparency, deterrence, and public confidence in competition. The evidence before this panel will demonstrate, to the requisite standard, that Mr. Fortuna was involved in match manipulation and acted in concert with his father and breached Article 20 of the FDC. While the illicit proceedings arising from that conduct were received by Mr. Fortuna's father, it does not discount Mr. Fortuna's own participation in the underlying misconduct. And with that, we turn to our first submission. Regarding the first issue, we submit that a statement of appeal filed by the appellant is admissible for 3 reasons. Firstly, the time of receipt begins on 31st May and not the 2nd of April. Secondly, the decision on 31st May is an appealable decision, making a deadline 21st April. And lastly, the actions of the appellant were not made promptly, which is a key requirement for reinstatement, which is why that should not be granted in today's proceedings.
Counsel, you had just submitted that the appellant did not act promptly. Could you explain why it was not prompt?
Certainly, Mr. Arbitrator. As found in 2024 CAS case of FC Football Club and Galatasaray, a lack of timely action by the council, even against the backdrop of technical issues, creates a fatal presumption that a party simply missed the deadline for no good reason. And in that case, the appellant have failed to provide compelling evidence to rebut this presumption. And in our case, there was ample opportunity for the counsel for the appellant to request for reinstatement. Firstly, if we disregard the cyber attack, the inherent nature of emails is that if it is indeed been sent, it will appear inside the sent folder of the counsel's email. And even without an error message, the fact that such a sent email notification was absent indicates that CAS likely did not receive the email. The appellant's legal team filed the highly sensitive statement of appeal at 23:45 Iridonian time as noted by counsel for the appellant. And yet, despite the extreme urgency inherently in such a late filing, the legal team had failed to proactively verify the receipt or follow up immediately. And at this juncture, they should have already contacted CAS to ask for reinstatement. Secondly, even if such a notification doesn't exist, Mr. Fortuna was informed about the cyber attack and its possible consequence on the 26th of April. Yet, they waited until Tuesday, 28 April to contact the CAS court office regarding the missing email and request reinstatement 2 days after they found out about the cyber attack. The delay of approximately 2 business days after learning that the attempt to file had failed is inconsistent with the strict promptness that's required by CAS jurisprudence.
So your submission is that a 2-day would disqualify them from acting promptly, would not fall within the meaning of prompt.
Yes, Mr. Arbitrator. The issue of prompt itself means that it must be immediate, as noted in the 2024 CAS case of FC Football Club. Thank you, Mr. Arbitrator. And regarding the issue of when the statement of appeal, when the receipt of the decision should be counted as, we do submit that it is 31st March and not 2nd April. In this respect, if I may direct the panel's attention to paragraph 23 of the record.
Yes, counsel.
The decision was fully upheld on 31st March 2026 by the FIFA Appeal Committee. Therefore, the appellant and his legal counsel would have had an opportunity to obtain knowledge of the decision on 31st March. And therefore, the relevant statutory date which triggers the 21-day time limit is 31st March and not 2nd April. Furthermore, the decision without the full grounds already forms an appealable decision. As noted in the 2015 CAS decision of GFF and SVGFF, a letter qualifies as an appealable decision if it affects the legal situation of the addressee, which means as if it contains a ruling. And as noted in paragraph 25 and 26 of the record, the FIFA Disciplinary Committee had definitely sanctioned the appellant for the manipulation of match fixing and sanctioned him to a fine of 100,000 Swiss francs. And notably, this already consists a ruling in which the appellant himself is able to lodge an appeal for. And therefore we submit that the statement of appeal is admissible. And unless I may be of any further assistance, I'll turn now to the second issue. We make 3 submissions. Firstly, the appellant has breached the non-negotiable duty to collaborate. And secondly, Article 6 of the ECHR is inapplicable to our proceedings. And lastly, even if the privilege against self-incrimination is invoked, it is insufficient to justify refusal. Turning to our first argument, the FDC imposes a clear, non-negotiable obligation on all participants to assist in establishing the facts of a case, especially when the integrity of the sport is at risk. According to Article 12 of the FDC, subsection 3, persons subject to this code shall help to establish or clarify the facts in the case of any possible breaches of this code, and in particular, shall provide any evidence as requested. And this leads us to the issue of mandatory cooperation, where persons subject to the FDC, such as Mr. Fortuna, shall collaborate to establish or clarify the facts, and this is an absolute duty. And there's a clear violation of such a duty. Mr. Fortuna knowingly and willfully refused cooperation, stating that the investigation could prejudice his rights to defend himself before the Iridonian Public Prosecutor's Office. In this present case, if I may direct the panel's attention to para 20 of the record.
Yes.
The appellant immediately refused to cooperate repeatedly when FIFA's representative requested that the appellant submit his mobile phone for the purposes of the investigation, and therefore this is clear breach of Article 12, subsection 3 of the FDC. Secondly, even if the appellant may seek to invoke the right to self-incrimination against self-incrimination, this is enshrined under Article 6 of the ECHR, which is not applicable to our proceedings. CAS jurisprudence consistently rejects criminal concepts, as noted in verbatim in the 2023 CAS Award of AGUS and UEFA. The parties' procedural rights cannot, in principle, be determined from the point of view of criminal law concepts enshrined in Article 6 of the ECHR. The strict application of criminal law principles in non-disciplinary proceedings, such as in non-state disciplinary proceedings, would prevent the fight against match fixing from functioning properly. And as proceedings before the CAS on the duty to cooperate in investigations is merely disciplinary and not criminal, Article 6 is not applicable. And
Counsel, but if what if there are, what if there are parallel criminal proceedings? Would that have any effect on your submissions?
No, actually, Mr. Arbitrator, and this actually has been supported by the 2013 CAS decision of Bestics Gymnastic v. UEFA at paragraph 174, where the court observed that corruption is by its nature concealed, and the parties involved will seek to use evasive means to ensure that they leave no trail of their wrongdoings. And therefore, in the case of a phone conversation related to match fixing, the panel considers that this position is also applicable, and people involved in match fixing will avoid using direct words, and therefore, the panel has no doubt that such conversations will occur in private, and hence phone records and conversations is crucial. Members of the panel, I note that my time has elapsed. If I may have maybe a further assistance on the last issue.
No, that's it.
This concludes my submissions. Thank you. I'll now hand over my time to Mr. Ramesh Kanna, who will address the remaining two issues on appeal.
Thank you, Counsel.
Good evening, members of the tribunal. My name is A. Ramesh Kanna and I appear for the respondent, FIFA. I have two issues to submit. Firstly, the anonymous email and anonymous witness statement are admissible evidence, and secondly, the appellant had indeed violated Article 20 of the FIFA Disciplinary Code. Now, with regard to the first issue, the evidence is admissible because it is admissible under both the FIFA Disciplinary Code and the CAS match-fixing jurisprudence. Now, with regard to the legal framework in this issue, Article 39 of the FDC on evidence and standard of proof provides three key points. First, that any type of proof may be produced, and second, that the judicial body enjoys absolute discretion regarding the evaluation of evidence, and third, that the applicable standard is comfortable satisfaction and not the criminal standard of proof beyond reasonable doubt. Now, with regard to the CAS match-fixing jurisprudence, CAS has repeatedly endorsed the comfortable satisfaction standard in match-fixing cases. For example, in the 2010 decision of UEFA and Orikov, the panel confirmed that comfortable satisfaction is the correct standard in corruption cases and explicitly noted that corruption is typically proven on the basis of indicia and circumstantial evidence, not direct proof. So what we see from here is that the CAS match-fixing jurisprudence is aligned with the FIFA Disciplinary Code. Now, under Articles 43 and 44 of the FDC, which deal with anonymous participants, Article 43 expressly allows granting anonymity where testimony may expose a person to threats or physical danger, and it lists protective measures such as the person not being identified in the presence of the parties, being questioned in writing, and keeping sensitive identifying information in a confidential file. Article 44 then requires that the anonymous person is formally identified by the tribunal in camera with only a confirmation and not their personal details released to the parties. So under the code, anonymous evidence is not an exception. Rather, it is expressly anticipated, regulated, and protected, especially in high-risk integrity cases such as match manipulation, which we face today. Now, if I could lead the panel to page 9 of the record at Exhibit 2.
Yes.
Is the tribunal with me?
Yes.
Okay. So turning now to the anonymous witness statement in Exhibit 2, the witness explains that he fears reprisals because the appellant's father is rumored to be connected to criminal organizations. That is a textbook Article 43, subsection 1 FDC situation, where disclosure of identity may trigger threats or intimidation. Substantively, the statement is both relevant and reliable because the witness personally observed two key things. First, the appellant was on phone with his father, and second, the appellant was shouting at his father to stop pressuring him and that, quote unquote, he cannot go along with everything. Now, CAS in the past has accepted this type of evidence where anonymity is justified and the evidence forms part of a corroborated mosaic, as we see in the present case. And the precedent for this would be the 2010 CAS decision of Orikov, where the panel stressed that corruption by its nature is concealed and that sports bodies must often rely on indirect and non-traditional evidence, including information from confidential sources, to reach comfortable satisfaction. This is the exact analogous situation that is present in front of us today, and that is why the anonymous witness statement should be admissible. Now, moving on to the anonymous email. It alleges a transfer of 50,000 dodgy coins to the appellant's father. This email is likewise admissible, and importantly, it is heavily corroborated. First, if I could refer the tribunal to Exhibit 5 of the record, which is the prosecutor's press release. I believe you could find it at
Exhibit 5?
Exhibit 5. At page 13 of the record.
Page 13. Okay. Yes.
Is Mr. President free?
Yes, sir.
The prosecutor's press release confirms that Mr. Luke Fortuna's dodgy coin wallet is under investigation by the Specialist Sports Integrity Unit. Second, Exhibit 4 of the WhatsApp screenshot also shows Luke the crook acknowledging receipt of the last part of the coin from the syndicate. Mr. President, Exhibit 4 is one page behind, at page 12 of the record. Apologies.
Sorry, so, counsel, in Exhibit 4, the father allegedly received the Dodge coins, is it? Dodgy coins?
Yes.
Okay. And this is an anonymous WhatsApp message? Or is it, where is this message coming from? It came through an email, right?
Yes,
That
Mr.
came from Exhibit 3?
Yes,
Okay.
Mr. President.
Okay.
Which alleges that this screenshot forms a part of a conversation between Mr. Luke Fortuna and the syndicate.
And investigators confirmed that Mr. Look has provided access.
Yeah.
Okay. But has it been proven that? Okay.
I understand the tribunal might find issue with the fact that beyond the email alleging this, it has not yet been proven. However, the respondent's case would be that the very fact that the public prosecutor is also investigating Mr. Fortuna's dodgy coin wallet shows that it is highly corroborated and that the email is reliable.
Okay.
And thirdly, under Exhibit 1, the Genius Sports Report records massive, unjustifiable betting for Comet Land and a red integrity alert. Exactly the kind of pattern one would expect if a syndicate had paid a key insider. So, Mr. President, we are not pitching our case so high as to say that the email has to be trusted baselessly. What we are instead saying is that given the fact that the email's claims have been corroborated by the Genius Sports Report and the public prosecutor's investigation into Mr. Luke Fortuna's dodgy coin wallet, we're saying that its reliability is enhanced. Now, with regard to the CAS jurisprudence, it is clear that anonymous intelligence is admissible if it is corroborated by objective data. And this was seen in multiple cases such as the 2014 decision of Sivasapur and UEFA and the 2013 decision of Besiktas and UEFA. Here, the anonymous email points to crypto payments, and the prosecutor's announcement and the objective evidence, which is the Genius report, both corroborate this. Thus, this is an analogous situation to the precedent cases.
But counsel, if I may just interrupt for a quick second, because in the witness statements, I mean, if we were to accept these statements, but the witness statement of Mr. Antonio in Exhibit 6, page 14, states that he was sick and he had a meeting with his doctor. At I think it's paragraph 10, page 15. But here he actually did meet his doctor, and then he still ended up playing the game even though he was under the weather. So could this be a reason why that he underperformed?
Well, if we were to look at the objective evidence, Mr. President, the signs of underperformance are not directly linked to the appellant's situation of feeling under the weather, because some of the mistakes that have been made are not linked to exhaustion or physical inadequacy, but rather direct breaches of fundamental basic skills of shooting. Now, I note that my time is about to elapse. If there are no further questions on the first issue, could I move on to the second issue, and could I request for 2 minutes to summarize my position?
Yes, counsel.
Thank you, Mr. President. Now, with regard to Article 20, there are three key points. Firstly, indirect involvement is enough. The player does not need to receive money himself, and acting under pressure from or in coordination with a third party, such as his father and the syndicate, still falls squarely within this article. And secondly, attempts and conspiracies are punishable. The fix does not need to be perfect or fully executed for the liability to arise. And thirdly, the standard of proof is comfortable satisfaction, as confirmed in the CAS cases of Orikov, Pobeda, and Sivaspor. Now, firstly, we should look at the betting anomalies. If I could lead the panel to Exhibit 1.
Is there a page for that? This is the
Page 8 of the record, Mr. President.
Genius Sport.
Yes.
Report. Yeah. Okay.
Before the match, there was strong betting against Iridonia, despite Cometland being bottom of the group, with 1 goal scored and 12 conceded. The odds for Cometland shortened dramatically with no sporting explanation. And this would go back to Mr. President's earlier question on whether these anomalies could have been linked to Mr. Fortuna's health. Because if that were indeed the case, the scoring did not have to shorten dramatically within a short period of time with no sporting explanation. Rather, the physical exhaustion would have taken a toll on him gradually throughout the entire play. And secondly, in play, within 20 minutes, Cometland went from a huge outsider to favourite, even though Iridonia dominated possession and chances. And around the 22nd minute, Pinibet and other major operators suspended markets immediately before Cometland's first goal. Now, this is independent of Mr. Fortuna's medical situation. And the CAS has already accepted in Pobeda and Sivaspor that such sharp, unjustified betting movements, especially when they lead bookmakers to suspend markets, are a strong indicator of manipulation and can even be decisive when corroborated by other elements. And when we look at corroboration by other elements, we look at the performance analysis. There's intentional underperformance. For the first goal, a misjudged lofted pass over an oncoming forward that is intercepted and rolled into an empty net. This is a series of highly unusual actions that have been objectively identified by the Genius performance analysis. And earlier, the appellant allows a corner to pass through his hands, which later then he delays a clearance until it rebounds off an attacker towards the goal. Throughout the match, there are repeated poor positional decisions which are once again independent of the appellant's health. Now, for these reasons, we would state that Article 20 has been breached. If Mr. President has no further questions, if I may be of no further assistance, I rest my case.
Thank you. We'll do a quick rebuttal. members of the panel, just one point in rebuttal. The respondent submitted that this privilege of self-incrimination cannot be invoked. However, we would like to argue against this. In the 2013 Jerome Valk versus FIFA decision, at paragraph 267, the court said only where there is a clear and imminent danger that the privilege against self-incrimination would be circumvented could such privilege also extend to investigations concluded by sports organizations. And here, in the present case, if I may ask the panel to turn with me to page 4, paragraph 15, at the top of the page. Is the panel with me? I quote here, FIFA, aware of the Iridonian criminal investigations, inquired whether the public prosecutor's office would be willing to share the evidence. And so here in this case, the respondent had been aware of that there was criminal proceedings. And the question is whether the privilege can be invoked. And here the court also stated that it is a debatable situation where there is a current criminal prosecution. And therefore we submit that we indeed can invoke Article 6, subsection 1 of the ECHR. This brings me to the end of my rebuttals. Thank you.
Members of the panel, one point in rebuttal. I note that the counsel for the appellant has raised the case of Velaki, and will instead raise the 2023 CAS Award, more recent CAS Award of Edgar and UEFA, where the CAS expressly held that the danger that the result of cooperation in fact-finding may later trigger a criminal proceeding per se is not a valid justification to invoke the privilege of self-incrimination. And this is analogous to our case, where the where the cooperation of the appellant in giving up his phone regarding regarding Article 12 of the FDC in itself is not a valid justification to invoke the privilege of self-incrimination. Unless I may be of further assistance, this concludes my submissions.
Just one point, counsel. You had just mentioned, or rather cited, the case that the words were the PSI privilege cannot be invoked per se if there was a criminal proceeding.
If it may at later trigger a criminal proceeding, and we do
Correct.
agree in this case that a criminal proceeding has been triggered, but that doesn't mean that that this is solely a case where FIFA has imposed a contractual obligation on the party to give up his phone in relation to disciplinary proceedings that occurs before FIFA itself and does not relate to external criminal proceedings.
Okay, counsel, because the reason why I mention it is because the cases cite this in Jerome as well, in Valk, and it stated that in Jerome the case was because there was no current proceedings, but appellant argues that in fact there is, and the case precedence says that it doesn't apply where it may trigger, but the distinction is that it may apply, as the court stated in Valk, that where there is current proceedings and that information may be shared with the public authorities.
Members of the panel, I do note that my time is elapsed. Just to answer your last question. Well, in Jerome Velaki, we do note that the appellant had similarly refused to be interviewed and he cited ongoing criminal proceedings. However, the CAS panel had rejected this defense, finding that the claims of criminals investigations were unsubstantiated. And while in our case, it is possible that the Iridonian public prosecutors are conducting a criminal investigation into Mr. Fortuna himself, there's no evidence to substantiate that the FIFA investigation poses a clear and imminent threat to circumvent his right before the Iridonian authorities, and his refusal was therefore unjustified under CAS jurisprudence. Thank you, members of the panel.
Thank you.